Look, he's making friends. There he is with his mouth open. It's still muted. Is there people that are muted? Why does he look like he's so spaced out? He's sitting there with his mouth open.
You're not on Wi-Fi.
I guess it wasn't working.
Hey, Miss Bridgewater.
Judge, how are you?
I'm good. How are you?
Good, good, good. Welcome back.
Thank you. 7. I think my page is printed out of order.
Our reset date for the SAP calendar is May the 29th.
All right. Good afternoon, ladies and gentlemen. My name is Judge Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before state court judge, so I am able to address certain matters such as possible arraignment, and any plea offers if they've been made by the state, as well as obviously bond. I want to let you all know again that the SAP reset date is May 29th. I also want to begin by informing the defendants that you have certain constitutional rights. The first being that you have a right to representation by counsel at this juncture in your case. You should know who your attorneys are by now and should have spoken to them. So again, listen to your attorneys and follow their lead. You also have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be held against you. The state is here and they're listening. So once again, follow the lead of your attorney. All right, I don't see who are the prosecutors for today. Are they not signed on yet?
I'm here, Judge Ryan Sirocco for the state. Good afternoon.
Good afternoon, ASG.
I'm on the Zoom.
I'm sorry.
ASG Justin Nixon for the state as well.
Oh, okay. Make sure you're muted when you're not asked to be spoken to or with, so that we don't get any extra noise from those who are not asked to unmute yourselves. Courtroom 2.
Hey, Judge, we can start with position 8, Ms. Herndon.
Okay.
Judge, we might need a breakout room for this for MH.
All right. This is the case of Aaliyah Herndon.
Raven Aaliyah.
I'm sorry, Raven Aaliyah. I apologize.
It's all right, Judge.
25 CR 002700C. So we need to have a quick breakout. Who's my Zoom master today? Miss Bridgewater.
Champion.
I'm sorry.
Miss Champion.
Oh, Miss Champion. Hi, dear. How are you?
I'm good. How are you?
Good. I think everybody needs to go into the breakout.
Okay.
Who is Shauna Gardner? What case are you here for?
You're muted, ma'am.
Can you hear me?
Now we can.
I'm Shauna Gardner. I'm here for Wilburn Petrie.
Okay. All right. You can mute yourself.
Your Honor, thank you.
Okay. So we just need the 2 PDs and the prosecutors to go into the breakout. Oh, hi, ASG Allen. And you need to be in there. I don't see the pictures of the others. Are they not on camera or just?
Mr. Sirocco is on camera and our new ASG Justin Nixon is just right there on camera.
Gotcha. Okay. I saw him at first and then he disappeared. And I thought it may be my view.
No, we
here,
tend
Judge.
to drop off out of sight because we don't want to confuse you as to who's handling the case.
Thank you. I appreciate that. All right. So Miss Champion is, here we go. Let's join. Everybody in there see me or no? Did Miss Herndon drop off or is she still on, Miss Champion?
She's still on, Your Honor.
She's still on? Yeah,
Yes, ma'am.
can't see her. Miss Herndon?
Yes, ma'am, I'm here.
Okay.
It says they blocked the video, well, now the video is showing.
Oh,
It's
there we
showing,
go.
Judge.
Okay, now I see you. Okay, I wasn't sure if you were still there. Miss Herndon, I understand that you've spoken with the state and they gave me a summary and some of those things we will not mention in open court.
Yes, ma'am.
But do you have a plan of action to help your daughter? Don't tell me exactly what it is, but do you have a plan of action to assist her if she were to get out today?
Yes, ma'am. I'm gonna put her in,
A location?
yes, ma'am.
Okay.
I do
And
know the name of it. I just can't think of it, but I do know.
I don't want you to say it
Yes,
either.
ma'am.
Okay. And so, is Raven Aaliyah working or anything
No.
like that?
No, ma'am. She'll be going to summer school.
Oh, she's got to finish her last year of high school.
But she's a junior, so she'll be going to the 12.
She's a junior in high
Yeah, her
school.
birthday is late, Your Honor.
Gotcha. Okay. All right. Well, here's what I'm inclined to do. And we discussed this in the breakout. And some of these things, as you know, we want to keep confidential.
Yes, ma'am.
And so, Raven Aaliyah, Herndon, can you hear me?
Yes.
Okay. So I'm going to give you a signature bond to let you go home, but it's only on certain conditions. And the first condition to go home is that you have to cooperate and listen to your mom and family members who are trying to help you, okay? And you've got to stay compliant with any medication or plan of action of treatment that they will let you know about, okay? And if you do that, you can stay out on bond. If you don't, you'll be back down here. Okay? So can you do that?
Yes, ma'am.
You can? Okay. So, and you're going to take whatever medication you need to take. Is that correct? Can't hear you.
Yeah.
Yes, ma'am.
Okay. Because you've got to finish high school. So you've got a lot to do. And I think she said you're going to summer school. You understand that? Yes? Okay. All right. Let's see. So on the first charge of simple battery family violence, I'm going to order a $2,000 signature bond. And on all of these bonds, she is to be released to the custody of her mom, Vivian Herndon. And second charge, disorderly conduct, 1,000. Criminal trespass, 1,000. Criminal trespass, 1,000, and terroristic acts, 2,000. That's 4,
Your Honor,
5,
I
6,
can't hear
7.
you.
Can everybody else hear me?
Yes.
I can hear you, Judge.
Yeah, not for sure why, Ms. Herndon. Can you hear me now?
Yes, ma'am.
Okay, I'll talk a little louder, a little closer.
No,
So,
it just the screen was breaking up. That may have been on mine.
I think it's on your end. So it's going to be a $7,000 surety bond.
Signature,
I'm
Judge?
sorry, signature bond. I'm sorry, $7,000 signature bond. And with that signature bond, I'm just going to make it through the jail per judge. And she is to be released to your custody, Ms. Herndon,
Yes, ma'am.
and that she will be compliant with any treatment and or medication that she needs to take on a daily basis.
Yes, ma'am.
She is to have no drugs, unprescribed drugs, alcohol, weapons, guns, or knives while on bond.
Yes, ma'am.
And did you get the breakdown too, Miss Bridgewater?
Yes, that was 2,000 on the first one and 1,000 on each additional
And 2,000 on the terroristic.
and on the terroristic, okay.
Mhm. And she is to have no further violent contact with you, Miss Herndon, or any of her other family members in the home, I understand?
Yes,
Maybe
ma'am.
a younger minor brother or other siblings. She's to have no violent contact, no further violent contact with any of the other persons in the home. I'll just make it broad like that.
Yes, ma'am.
And I guess that'll be it. Anything else from the state or PD's office?
We would ask for that signature bond to be through through pretrial services. So there's supervision and monitoring, but that is the only ask, Judge.
Mhm. My only concern is that she's 17. I don't know if she has a car. She can
She
call.
doesn't, Your Honor.
Yeah, she's still in the 11th grade. As long as her mother, I don't want to put any more stress upon mom having to be monitored by pretrial. I think the biggest thing is that she get her in something else that will do that. And mom, will hopefully be able to control her going forward so that she will be back in court when needed and hopefully get some help. Okay.
Yes,
All right.
ma'am.
All right.
And I work for the city,
Yeah, I understand that. Well,
so
as
I
I said,
work
good
12
luck to
hours,
you.
but
Yeah, do
I
you have
make sure
someone
she's
that'll
seen
be with
about.
her? Right. Do you have someone with her or checking on her?
Yes, ma'am.
Okay. All right. So we hope Raven and Leah, please cooperate with your family. They're only there to help you. Okay. All right. That's it. Thank you.
Thank you, Your Honor.
Uh-huh.
Next is position 2, Ms. Bowdry.
This is 25 CR 002690J. Tierra Baldry charged with 3 counts of reckless conduct. This is her first arrest. Is that correct? Yes. All right, go ahead, State.
Yes, Your Honor. The state is simply asking for a $300 signature bond for all 3 counts of the reckless conduct. This incident occurred on May 14th, 2025. An officer was dispatched to 222 Pine Street Northwest. That's Atlanta Unit 203 on a call regarding an abandoned child. And upon arrival, the caller reported that a young male, later identified as a minor child, initials JF, was unsupervised in the street. The child is reported to be nonverbal, and the caller brought the child to safety and waited for police. Now, the officer was advised of a similar incident that occurred at this address 2 weeks earlier. While they were waiting for EMS, the defendant arrived and stated that she was unaware that she had left, that the child had left the home. She said that she left for work at 6:15 a.m. while her children, JF, and 2 other minor children, TF and JM, were asleep, and that her friend, Brianna Stewart, was supposed to watch them. Now, Ms. Stewart claims she arrived at the home around 10:30 a.m. after the defendant called and asked to check on the children. And when she arrived at the location, Ms. Stewart found only 2 of the 3 children, TF and JM. Now, Stewart's boyfriend was at the location and stated that he and Ms. Stewart arrived together around 12 p.m. after visiting a car dealership. A neighbor and former nanny, her name's Jerica Matches, also received a call around 10 a.m. to check on the children, only found 2 present. SVU was notified and DFAC's worker responded to the location. I have been notified that the grandmother of the juveniles is on the Zoom here. Again, as stated, this one cycle, the state is simply asking that the defendant comply with all DFAC's orders and recommendations and no alcohol, drugs, or weapons while out on bond.
All right, and is it Ortiz or Ortiz? Ortiz? Are you with this case? Can't hear you.
I'm actually waiting for my son to be seen. Christopher
Okay.
Ortiz.
No,
Okay. Sorry about that.
Your Honor, I'm the victim advocate. The grandmother is Tara July.
And is she on?
Yes, she is.
Right, can't see her. And the grandmother, Miss July?
Hello, how are you doing, Your Honor?
I'm fine. Are you driving?
I'm actually sitting in the car. I'm not driving.
Okay. Well, I don't really necessarily need to have any testimony from you. Were you on the scene that day?
Yes, I arrived at the scene to get my grandkids.
Okay.
And
Well, that's fine. Just want to make sure that they're safe.
they
And
are.
okay. And they're with you, so that's fine. And I'm going to go with the state's recommendation for the signature bond. And is this your case, Mr. Chataya?
Yes, Your Honor.
Okay. And I will grant that $300 signature bond. Do you have anything else you want to add?
No, Your Honor.
Okay. And I believe that would be 100 on each of the charges, or a total of 300. Is that correct, Mr. Nixon? ASG Nixon.
Yes, that's fine. That's correct.
All right. And I'm going to also order that the defendant cooperate, I guess, with her grandmother and whomever will have temporary custody of the children, as well as comply with any defects, requirements or recommendations regarding the safety of the children, or any plans of action that defects may put in place as well if they're already involved in the case. No unprescribed drugs, alcohol, weapons, guns, or knives while on bond, and no further violent contact with the victims, and minor victims or adults in this case. Anything else?
No, Your Honor, from the state.
Right, and that SOB would be through the jail.
What's that amount?
$300,
Like
100
one.
on each.
Okay.
That was the state's recommendation. All right, anything else? All right, next case.
Thank you, Your Honor.
All right, you're welcome. Thank you.
Position 5, Ms. Daniel.
This is 25 CR 002698C. It's at Romita. Daniel, charged with 1 count of theft by shoplifting. And
She got 8 total. 2025 shoplifting, 14 shoplifting, 11 shoplifting trespass conviction, another arrest in 2011 shoplifting conviction, 2010 shoplifting conviction. That's it.
all right, state.
Yes, Your Honor. The state has asked for a $1,000 surety bond for theft by shoplifting. The incident date is May 12th, 2025. And on this incident date, Officer Watts was assigned to work at 844 Cleveland Avenue, East Point. And that's the Walmart there, that location. And while working, Walmart asset protection members alerted him that the defendant was observed shoplifting through the store. The defendant attempted to exit the building when she was stopped by members and officers for a brief detainment for the investigation. Now, while attempting to exit the store, she was in possession of approximately $183 worth of merchandise in several bags in her cart. She does have prior shoplifting convictions. This should be a felony. We've reached out to the district attorney's office, but have not heard back yet. The state is asking for a stay away from the Walmart location at 844 Cleveland Avenue in East Point, as well as no alcohol, drugs, or weapons were out on board.
PD Chataya.
Thank you, Your Honor. I'd ask this court to consider the lowest surety amount possible that's reasonable for her case, and potentially even a signature bond. Ms. Daniel is 38 years old. She's been an Atlanta resident for over 12 years now. She got through school as far as the 10th grade, and she currently doesn't have a job. She's unemployed and wouldn't be able to afford the surety amount that the state's asking for. But before she became unemployed, she worked as a cleaner for a couple of years. I'm not sure exactly how many years, and she wasn't able to tell me, but she told me she worked in cleaning. So for those reasons, I asked the court to follow my recommendation.
All right, I'm going to order the $1,000 surety bond. And with that surety bond, a stay away from the Walmart on Cleveland Avenue, 844 Cleveland Avenue. And no drugs, unprescribed drugs, alcohol, weapons, guns, or knives while on bond. And I guess there's no other conditions that I need to add at this time. Is that correct?
That's correct, Your Honor.
All right, 1,000 surety.
Good afternoon, Judge.
Good afternoon.
I have position number 6, Ms. Forrest, and if you can please read her right.
All right. Ms. Forrest, you have a right to representation at this time. And I'm sure you've had a chance to talk with your attorney, so follow their lead. The state is here and they're listening. So remember, anything that you say can and will be held against you. You also have a right to remain silent and follow the lead of your attorney at this hearing, okay? This is 23 CR 002692G. Tiara Forrest, charged with 1 count of battery family violence. Pretrial.
Third. All she got is marijuana charges. That's it.
Okay. All right, state.
Yes, Your Honor. State is asking for a $1,500 surety bond for the battery family violence. The incident date is May 13th, 2025. An officer was dispatched to 1870 Campbellton Road Southwest, apartment M9, for a person injured during a dispute. And upon arrival, the officer met with the victim, Derek Randall, and the victim was bleeding from the face. Now, the victim stated that a female that lived with him, the defendant, bit him in the face. He stated that she fled the scene, and a passerby stated that she was entering an Uber SUV to leave. The officer then proceeded to stop the vehicle, and the defendant stepped out the vehicle, and the victim confirmed that this was the person who assaulted him. And as the officer detained the victim, she stated, "That's why I whipped your expletive." The officer noted that she made threats of physical harm to the victim and called him derogatory words in his presence. Now, with regard to the victim, it was noted that the victim and defendant lived together. State is interested in promoting a cooling off period between the two parties. The victim, our office did speak with the victim. The victim confirmed the events except for the last portion of the incident report, where the victim stated that he told the officer he wasn't interested in pressing charges. The victim stated the officer told him it's too late and proceeded to press the charges. The victim did not want to press charges because he did not want to see the defendant's chances of getting a job hurt, or because they're kind of in a relationship, is what the victim stated. The victim and defendant, again, are living together, and the victim stated that this has never happened before. The victim wants no further violent contact, and the victim and defendant do not share children. The state is asking for no further contact between the victim, again, the victim and the defendant, to promote a cooling off period, a stay away from 1870 Campbellton Road Southwest, apartment M9, anger awareness, and no alcohol, drugs, or weapons while out on bond.
PD Chitaya.
Thank you, Your Honor. My client is 33 years old. She's lived in Atlanta for the past 13 years. She has an associate's degree as a medical assistant, and for the past 3 years, she's worked as a delivery and taxi driver. Right, no objection to the no further contact and stay away request from the state. Given her ties to the community and her stable employment history, I would ask the court to consider the lowest surety amount possible. And if the court is willing, a signature bond would be appreciated.
All right. I hope she has somewhere else to go live.
She does, Your Honor.
All right, I'm going to order $1,000 signature bond through pretrial. I'm going to order that she take 2 days of anger awareness through pretrial. I'm going to order that she stay away from 1870 Campbellton Road and go stay elsewhere while she's on bond. To have no further contact right now with the victim, Derek Randall. And that's no further contact. No unprescribed medication, drugs, alcohol, weapons, or guns and knives while on bond. And did I leave anything out? I think I didn't. Anything else from council?
It's all from the state.
Your Honor, what level?
Level 1.
Thank you.
And that's it.
Thank you, Judge.
All right, thank you.
Next is position 1, Mr. Bibbs.
This is 25 CR 002689A, Willie Bibbs, charged with 6 counts of forgery in the 4th degree.
Third
Pretrial. Yeah. go
third
ahead.
arrest, 2014 FTA, 2014 trespass conviction.
Dave?
Yes, Your Honor. State is asking for $900 surety bond for each of the counts of forgery in the 4th degree. The incidents took place between May 29th, 2024, all the way to June 2nd, 2024, in various locations and incident dates. Now, on May 26, 2024, a report was reported advising of vehicles being broken into at 3000 Union Road Southwest, with Harold Simmons, the victim, advising of multiple things being stolen out of the vehicle. The victim advised that they noticed that there were several checks that were removed from his checkbook, and he advised that he is the registered owner of the bank account that the checks are assigned to. The victim advised that he was notified of several deposits being made at different Navy Federal locations, and those locations are as follows: 2470 Briarcliff Road, Northeast Atlanta; 2980 Cobb Parkway, Southeast Suite 100, Atlanta; 113 Georgia 138 in Stockbridge; and 5140 Windward Parkway, Alpharetta. And those checks were cashed in approximate amounts of over $960. The victim advised that he did not provide permission to anyone to remove any amount of money from either account, and eventually contacted Navy Federal locations to report the deposits as fraud. Camera footage was obtained along with a copy of each check from the locations that showed the defendant submitting the checks into a personal account. And after the surveillance was reviewed, the defendant was submitting the checks in the same clothing at different locations. The defendant signed each check on a line paid to the order of, where he signs his first and last name, Willie Bibbs, with an unknown name located at the bottom of the check and indicating the wage or tips or work. The defendant submitted in total on different days 6 unauthorized checks. Now, the state is asking for no further contact with the victim, Harold Simmons, stay away from the aforementioned locations, and no alcohol, drug, or weapons while out on bond.
All right. PB Atar? I'm sorry, Chitaya.
Yes, Your Honor. My client's a lifelong resident of the Atlanta area. He's 28 years old. He's a graduate of high school, and he's worked as a fast food cook for the past 7 months. So he's trying to hold on to his employment. For those reasons, Your Honor, I ask for the lowest surety amount possible, or otherwise a signature bond if the court is willing to allow that.
All right, I will order a $1,800 surety bond And that will be 6,000 on each of the charges. I didn't do the math right on that. 600, yeah, times 1, 2, 3, 4, 5, 6. So 6 times 6 is 3,600. Is that better math?
Yes, it is.
Thank you. All right, so 600 on each of the forgery charges for a total of 3,600 surety bond. I'm going to order that he stay away from the Navy Federal Credit Union, stay away from all of them. Sounds like he doesn't have an account there in the Atlanta metro area. I have no further contact with the victim, Harold Simmons. No drugs, alcohol, weapons, or guns, or weapons while on bond. And that will be it.
Next is position 3, Mr. Cartwright.
$25 CR 002691C. And this is the Cartwright charged with 1 count of harassing communications and 3 counts of electronically transmitting or posting nude or explicit photos or videos.
He got 81 total. He got a probation hold, CPO out of Douglas County, history out of Washington, South Carolina, Florida, and Alabama. Got 3 open cases in Fulton County Superior Court. 2024 theft by receiving, on probation for 2 counts of theft by taking. 2022 trespass conviction, 2018 failure to appear.
All right, state.
Yes, Your Honor. State's asking for a $2,000 surety bond for the harassing communications count and $2,000 surety bond for each count of electronically transmitting sexually explicit photos. The incident date was January 8th, 2024. The victim, Sherlon White, her first name spelled Shearlon. White reported that the defendant sent a picture of the victim engaged in intimate contact with the defendant to 3 different individuals. She stated that she did not give him permission to take the video or to send it to others. Now, as pre-child mentioned, just in, I think in Georgia alone, it's 55 cycles. Our office has contacted the victim, and actually, our office has actually met with her today in person. And the victim stated that the defendant texted the photo to 3 people. She stated that she didn't know that the defendant took the photo, nor did she give him permission to share. The victim believes that the defendant did this out of spite, and the victim and the defendant are not in a relationship. Now, the victim and the defendant lived together off and on from 2015 to 2018, and they don't share any children. And he stated that this has never happened before, but the victim is afraid. She stated that the defendant has charges in Douglas County. Victim wants no further contact and a stay away. And the victim stated that the defendant busted out her back windshield while he was wearing ankle monitor in 2024, and she should be on Zoom. But I want to be clear here that the defendant has multiple open cases and convictions. I think an open kidnapping. And the warrant was taken out in enough time, and he just wasn't served with this. But this case is a bit egregious. So the state is asking for no further contact with the victim in this case, to stay away from her address, and no alcohol, drugs, or weapons while out on bond.
All right. PD Chataya.
Thank you, Your Honor. I asked the court to consider a signature bond for the following reasons. 1, he has a large number of open cases, so he wouldn't be able to get out of custody anyway. 2nd, my client informed me that at the time that the incident is alleged to have taken place, he was actually in custody in a different county in Georgia. So I found that odd. 3rd, I looked at the affidavits for arrest, and it looks like they were sworn to by a private individual and not an officer. There's a Sherlon White. I don't believe this person's a police officer. So I found that pretty suspicious, given that all the other cases we have on this calendar are just written by officers in the form of an affidavit for arrest. But those aside, Your Honor, I'd like to emphasize that my client does have ties to the community. He's 42 years old and he's lived in Atlanta for the past 25 years. He tells me he has a bachelor's degree in business administration, and he also has a technical certificate for automotive body and collision repair. And prior to being incarcerated, he was operating an automotive rebuild shop, of which he was the sole proprietor. So he has stable employment here before he went to prison or jail. So for those reasons, Your Honor, I ask the court to consider a signature bond for Mr. Cartwright's cases.
Okay.
And Your Honor,
Go ahead.
I just wanted to add this, it's no consequence that these warrants were privately sworn. I want to reiterate that the victim is scared and she brought the evidence to our office today. So I just want to just be abundantly clear.
Got you. All right, I will order the $8,000 surety bond, which is $2,000 on each of the charges. With that surety bond, I'm going to order a stay away from the incident location. I'm going to order no further contact with the victim, Cheryl White. No drugs, alcohol, weapons, or guns, or knives while on bond. And I believe that is it. Anything else, counsel?
Nothing further from the state.
Nothing further, Your Honor.
Thank you.
Next is position 4, Mr. Carr.
This is 25 CR 002697F. Kenneth Four COER. One count of failure to obey traffic signs and signals, seatbelt violation, and driving while license suspended or revoked. Retrial.
2024 suspended license. 2 from 2023. 2017 suspended license conviction. 2014 driving without a valid license conviction. 2013 suspended license no-load. And I stopped there.
That's fine. All right, state.
Thank you, Judge. This incident took place May 9th, 2025 at 3840 Sylvan Road is where they approximated the stop at. The law enforcement was observed a vehicle going through a red traffic signal while traveling north on Sylvan Road. This was in East Point. Law enforcement conducted a traffic stop. And when approached, the defendant asked the officer to, quote, cut him a break due to his license being suspended. The defendant provided his name and date of birth instead of a license. The officer also observed the defendant's seatbelt was off. GCIC, NCIC check confirmed the defendant not only was his license currently suspended, but it had previously been suspended a number of times dating back to 2012. He was placed under arrest at that time, and the vehicle was turned over to another passenger. With respect to not only that, the convictions alluded to by pretrial, I see as well. Open, some of these are dormant due to FTAs. But others are not. 23 CIT 004782, failure to have license on person. It looks like that was amended from driving while license suspended or revoked. It's unclear to me whether there was a plea taken on that, but I do see, weirdly enough, an FTA for the trial date on it's December 16th of last year. 24 CIT 000186, another driving while license suspended or revoked, failure to obey traffic signs, signals, and markings. FTA for that trial date that was in 2024 in May. Another driving while license suspended or revoked, 23 CIT 010179. And then those I believe are the dormants. There's four other like open cases. One with driving while license suspended or revoked, operation of a vehicle without a revalidation decal, another driving while license suspended or revoked, and expired tag or unregistered vehicle. Those are four separate cases. Given the, I mean, the open cases, the convictions, he's a repeat offender. He's likely to repeat again with this driving while license suspended or revoked. Can't be allowed to continue doing that. The state is asking for a split bond signature bond for the failure to obey traffic signs, signals, and markings, and the seatbelt violation, and a $3,000 surety on the driving while license suspended or revoked. No drugs, weapons, or alcohol while out on bond. And if there are any provisions or conditions, related to restricting his driving in some way, outside of no driving without a valid license, we would defer to the court on those as well. Thank you, Judge.
Okay. All right, Mr. McLean, PD McLean.
Your Honor, Mr. Moore is 61. He graduated from a local high school. He's been on disability for several years, about 6 or 7 years, with gout, high blood pressure, several physical conditions. So he's on a very limited income. He has stable address. He lives with his brother at that address. Gets good mail service. So that shouldn't be a problem with getting mail for court notices. We'd ask the court to consider a signature bond. There's something I've always been curious about. Do we set a bond on something that the maximum fine is $15 for the seatbelt? And
well, I think I have to.
okay.
And like I say, he's giving him a signature bond. It'll probably be a low signature bond on those two. So the failure to obey traffic signs and signals, I'll give that $100 signature bond. And I'll make that through the jail. And on the seatbelt, a $50 signature bond through the jail. And then the suspended license, $200 signature bond through the jail. So I'm going to make all of them. That'll be a total of $350 SOB jail. No driving without the proper credentials, whether it's license, insurance, registration, and no drugs, alcohol, weapons, or guns while on bond. And that's it.
Next is position 10, Mr. Ortiz.
This is 25 CR 002699C. Christopher Lewis Ortiz, charged of 1 count of simple battery, family violence. Pre-trial.
I didn't note the total number, but 2024 disorderly conduct, 2024 simple battery DV, 2015 possession of a controlled substance, 2014 robbery, unlawful possession of a weapon. Then he did PTI and it was dismissed. That was another state.
All right, state.
Thank you, Judge. So this took place May 14th, 2025. Law enforcement responded to 3805 Springfield Lane in South Fulton in reference to a domestic dispute. Upon arrival, the officer made contact with the victim in this case, Miss Destiny Murray. We I'll say this, we did dismiss her case. She was arrested with for the same incident. And I'll get to that in a second. Made contact with her and the defendant. She explained that she was in a verbal altercation with him that became physical. She lives with him, shares a child with him. She explained that the defendant punched her in her face. Officers didn't observe visible marks for that, but the defendant did admit to grabbing and ripping her shirt. It was his claim that it became physical when Miss Murray threw a candle at him and bit him on his finger. He did sustain some superficial injuries. He also stated that he did not want to press charges because he was currently out on bond for a domestic violence case involving a similar altercation, which I will get to. Both parties were arrested, as I said, and we have dismissed Miss Murray's case. It's the state's belief that the actions she was arrested for were taken in self-defense. On that other simple battery family violence, it is against her. It's the same victim. 24 CR 006478C, that open case. It was from last September, where he is accused of slapping her several times, holding her to the ground. He apparently took her phone as well, so she had to run across the street to a neighbor's who helped call the police. And ultimately, that case, the incident at least, ended with the victim's brother arriving, and there was a sort of standoff between those two where the defendant pulled out 2 knives. With this case, he is in violation of his bond for that case, which was a $1,000 signature bond through the jail, where he was ordered to have no further violent contact with Miss Murray. No stay away was ordered for that case, but we are certainly going to be asking for it here. As we've just dismissed her case today. We haven't been able to speak with her yet. We would, of course, ask the court sound for her in accordance with Marcy's law. But in any case, the state's recommendation here is a $4,000 surety bond for him to complete FFIB, have no further contact with Destiny Murray, stay away from 38005 Springside Lane in South Fulton, and no drugs, weapons, or alcohol while out on bond.
All right. P.D. McLean? Or no?
It's
Or
my
Mr.
case,
Fox?
Your Honor. Good afternoon.
I'm sorry. Good afternoon.
Yes. I would ask the court to consider a signature bond for my client, and here's why. I read the warrant, and it clearly states that even though the alleged victim said that she had been punched by my client, there was no evidence whatsoever. She didn't have any redness, any markings, or anything that would suggest that she had been punched. And in fact, my client did have a bite on his finger. The warrant is very clear about that. So I am at a loss as to why the state chose to dismiss the case against her when my client was the one who had the injury. It seems to me that this is a situation of gender discrimination, Your Honor, because my understanding is that the last time they were also both arrested. This time they were both arrested in the state with absolutely no evidence that my client did anything other than mere allegations, chose to dismiss against her when he had injuries. So that is my position here. They do share a child, Your Honor. My client tells me that they, in fact, do not live together. He has given me an address in Forest Park and says that that is where he lives. So I would ask the court to consider a signature bond because I am really not quite sure what happened here, why the state just decides in the face of evidence that she did, in fact, physically attack him, that they would dismiss against her, but to have him sitting here. Nothing further, Your Honor.
I will say, Judge, the accusation specifically is for grabbing her. which we believe started all of this. And that is what he actually admits to in the when officers spoke with him. So I will include that. Also, the open case as well. That factored into the state's decision too.
But I would say this, the bond was no further violent contact. He did not have any violent contact with her. They were having an argument, and if the so-called grabbing, I'm not too sure what happened there. There must have been something that happened. She bit him, and I think that is undisputed that she did that.
How old is the child that they have together?
How old is the child, Your Honor? I believe the child is 8 months old.
Oh, small baby.
Yes.
Okay. And normally, Miss Ortiz, we usually don't have a lot of family members. I don't know if you were on the scene at the time as a witness or just coming here today. Are you just coming here today to support your son?
You need to unmute.
Unmute. Here we go. Hello, Your Honor. So no, I actually live in the state of New Jersey, but I was on the phone while the incident was occurring. And yes, Destiny is not just, she's not so innocent.
So hold
Not
on a
saying that
second.
my son
Hold
is
on a
innocent.
second. Hold on a second. This is not the trial. And we're only here to decide bond. And I do understand. And I also base that on your son's history. And he's got a couple of things there.
But it's his word against hers because at the end of the day, she is very provoked. She provokes him, and he does live here, there. He has mail that goes there. They are in a relationship.
Okay. And I get it. And I want to make sure that they're cooled down, that we don't have any more incidences prior to this case going to trial or going further in the process.
I agree.
So I'm not going to hear much more regarding the relationship, because again, that's between the two of them. And so is this an apartment or a home at the Springfield Lane?
A home.
Okay. And it's being rented, I guess?
Yes, it is rented by them both.
By
They
them
both
both.
are on the lease.
Both on the lease, okay.
Yes, ma'am.
All right. And I know that she has this 8-month-old child. So what I'm going to have to do is I will order a $1,000 surety bond. And with that surety bond, I'm going to have Mr. Ortiz to find somewhere else to stay in the interim. You can talk to his attorney regarding modification of the bond. But right now, to make sure that there has been the cooling down period between the two of them, he needs to stay away from that location. Needs to be no further contact with them right now. Again, to make sure that they get beyond this case today.
Yes, ma'am.
I'm going to order no drugs, alcohol, weapons, or guns while on bond from Mr. Ortiz. So the stay away, no further violent contact. Let's do that for a moment, see how that goes. And then you can speak to his attorney to go, any further from there.
Is it no further
I will
contact or
give
no
him-
further violent contact,
Yeah, I'm
Judge?
confused
There
too.
was
Oh, I'm
violent
sorry.
contact in the last one.
I'm sorry, no further contact.
Okay.
No further contact. I will allow him a one-time law enforcement escort to go back to the property to retrieve any personal belongings that he may need to get. And again, Mr. Ortiz, you must arrange that by law enforcement. Do not go back on your own. All right. Do you have a question about the bond?
No, I don't have a question about it.
Okay. I saw you raise your hand, so your counsel will talk to you about that. All right. If there's nothing else, that's it for this case.
Thank you, Your Honor. That concludes my
Thank you,
business
Your
before
Honor.
the court today. May I be excused?
Yes, you may. Thank you. And thank you, Ms. Ortiz.
Well, thank you,
And
Your Honor. I
Mr.
appreciate it.
Ortiz, when you are released, please give me a call.
Yes, ma'am. I will do that. And thank you, guys.
Okay.
Have a nice day.
All right,
What was that bond?
$1,000 surety.
Thank you.
Next is position 11, Mr. Petrie.
This is 25 CR 002695F. Wilburn Petrie, charged with driving improper erratic lane change and failure to report striking a fixed object.
Third arrest, you got open DUI out of Cherokee County. 04 deposit account fraud conviction.
All right, state.
Yes, Judge. So this, on May 10th, 2025, law enforcement was dispatched to the intersection of Rucker Road and Willis Road in Alpharetta in reference to a hit and run with a street lamp, even though that's not quite the way the charge is described. Upon arrival, the officer observed that the street lamp on the sidewalk had been completely knocked over, with a piece of wheel well of the vehicle that struck the pole and other various parts scattered across the sidewalk and the street. A third-party caller had advised that the suspect's vehicle had front-end damage and provided a possible license plate number, which returned a particular vehicle model. And using flock cameras, the officer actually observed the suspect's vehicle with visible damage to the front passenger side wheel and the bumper area. The officer contacted the registered owner, a Mrs. Sally Cool, who was initially uncooperative, but during a subsequent phone call, Mr. Petrie, excuse me, admitted to being the driver of the vehicle at the time of the collision. Now, a Cherokee County deputy, because this is Mr. Petrie's residence is in Cherokee County, went to that residence to meet him. He admitted to drinking at a tavern for roughly an hour and a half and was unable to provide a specific amount of how much alcohol he consumed. He admitted to driving the vehicle at the time of the collision and advised that he had not consumed alcohol after arriving home. He stated he was aware that he had been involved in a collision, but did not apparently believe there was any damage to his vehicle despite everything that's been described. So he continued home. HGN testing was done on him and they observed 6 out of 6 clues. That is an open, so this is directly related to an open DUI case out of Cherokee County. Additionally, he does have a previous DUI case from 2004. I don't have the disposition for that, but not his first DUI case. And while this isn't a DUI case itself, the circumstances surrounding present concern here similar to the nature of a DUI. The state therefore is asking for a $1,000 surety on each count for a total of $2,000 surety. No drugs, weapons, or alcohol while out on bond.
All right. PD McLean. Can't hear you. You're on mute.
So sorry. Thank you very much. He is 77, lives in Woodstock. The bonds already had been mentioned on the 3 card, but I don't know if they were set or if they were just off of a schedule and they fill them in. I don't know how that works exactly, but they were 250 and 105. He had not yet made that. I think that his adult children may live in Florida and maybe they need somebody to, as a Georgia resident, to go do something. So, bond wise. So I would ask the court to consider a signature bond. He's retired. The last job he had was selling cars at Classic Cadillac in the past. He's went through high school and has a stable address. So we would ask the court to consider a signature bond in this situation.
All right. I will order $2,000 signature bond, 2,000 signature bond, 1,000 on each of the charges, and that signature bond will be through the jail. I will order no driving unless he has a proper license and credentials to drive. I don't know if he still has his license or not. No drugs, alcohol, weapons, or guns, and knives while on bond. And I guess that's it. Anything else, counsel?
Nothing.
Nothing.
All right, 2,000 SOB jail.
How do I talk?
Someone's there?
He's talking.
Probably his daughter Shauna.
Yes.
Oh,
Can you
okay.
hear-
I can't see you, unfortunately. Let's see.
I got a temporary license from Cherokee County and not allowed to drive on that.
It said a temporary license to Cherokee County, and what was the last thing you said?
Not allowed to drive on that license.
Okay.
Okay.
All right. Let's be careful.
Next is position 12, Mr. Weathersby.
He's going to be signing himself out, Miss Gardner.
Okay, thank you.
All right, thank you. I'm sorry, which position?
Position 12.
Oh, Weathersby. All right. 25 CR 002696A. Curtis Weathersby, charged with 1 count of criminal trespass.
48, 2017 theft, trespass, conviction, 2011 trespass conviction. I didn't go past the 2011, but it's 48, so.
Right. Thank you. State.
Yes, Judge, this incident took place May 14th, 2025 at 2370 Metropolitan Parkway Southwest. It's an apartment complex, Santa Fe Villas. Law enforcement responded to a report of a criminal trespass. Upon arrival, the officer spoke with the property manager, Michelle Montgomery. That's Michel''L''E. Montgomery, who informed the officer that the defendant had previously been warned with respect to a criminal trespass on June 24th, 2024, and was arrested for being an unauthorized person on the property on July 25th, 2024, same location. She explained the defendant frequently visits the apartment, but typically leaves before officers are able to arrive. However, on this occasion, he remained in one of the apartments there that belonged to Miss Belinda Miller, and he was refusing to leave. Miss Miller is of diminished mental capacity. I will say that and there is additional care that's required for her there. The defendant was placed under arrest. Ultimately, you know, he's got, what was it, 48 cycles? Not his first rodeo with criminal trespass convictions from 2017, 2011. We would just ask that the signature bond, for a signature bond, but through pretrial services to make sure there's some monitoring here, because we're asking for a social worker visit for PHET. No further contact with either Michelle Montgomery or Belinda Miller, and for him to stay away from the that is the Santa Fe Villas apartment complex at 2370 Metropolitan Parkway, and that is in Atlanta. No drugs, weapons, or alcohol while out on bond.
Yep. Phoebe McLean.
Your Honor, Mr. Weather is 70. He had a stroke. He's got congestive heart failure. They've installed a defib in him, he says. I think he has some confusion about where to live, where he lives. I understand from trying to interview him as best I could, that he uses the 1328 Peachtree, which is a church which has a good reputation as being a reliable mail service for people who need the mail service. I called that church. I talked to the community ministry people there. They said, yes, he does have the mail service here, but when he refers to his payee on his Social Security being a certain last name, they said we probably were not, unless we referred him to another agency, which of course we do frequently refer people to other agencies for other needs. We don't actually set up payee situations. So he's got a payee somewhere in some agency. He's got a case manager. It might be at Mercy Care. So they did their best in looking at their records to see where he might be, where he has a case manager. So Mercy Care probably has him as recently as 2023, a couple years ago, according to that church's records. So no objection to the signature bond. I'm doing my best to get I'm going to have our social worker see about calling Mercy Care to see if we can't track down who is his case manager. We think we have a last name for his payee.
Okay. So for that, one count of criminal trespass, I will order $1,000 signature bond through pretrial level 1. So he can call in if he needs to.
Level 1.
Or level. What was the recommendation?
You can call once a week.
Okay. Oh, well, it can be a 2 if you want. You want to make it level 2?
That's fine.
Okay.
It's going to be a case manager calling in. If I mean, he won't know how many times a month to call in. We've got to track that down.
All right. 1,000 SOV pre-trial level 2. I'm going to order that he stay away from the Santa Fe Villas apartment complex on Metropolitan. I'm assuming he obviously doesn't live there, so he's to stay away from that apartment complex. No drugs, alcohol, weapons, or guns while on bond. That should do it for now.
Next is position 7, Mr. Gunn.
This is 25 CR 002693C. Shamar Gunn, charge of 1 count of 2 counts of PI. Can you stop the live streaming, please? Miss Champion.